Breaking news. Welcome to today's headlines. Nnamdi Kanu winning. See what court plans to do on February 28th that will make Igbos happy. Nnamdi Kanu winning. See what court plans to do on February 28th that will make Igbos happy. To my dear listeners from wherever you're listening from, stay tuned as I read today's news. Nnamdi Kanu, the head of the proscribed organization HIPOB, has taken the DSS and the AGF to court for allegedly violating his fundamental human rights. The DSS and the AGF, on the other hand, filed a counter affidavit rejecting the accusations in Kanu's section. On Monday, February 7, the presiding judge, Justice Taiwo, scheduled the hearing for Monday, February 28. Nnamdi Kanu is scheduled to appear in court again, according to a report by PM News. The Federal High Court in Abuja has scheduled Monday, February 28 to hear a fundamental rights enforcement suit filed by Nnamdi Kanu, the leader of the outlawed indigenous people of Biafra, HIPOB. According to the publication, Justice Taiwo said the date after DSS counsel Idowu Awo informed the court that his client had a counter affidavit that had not been served on Kanu. Awo requested extra time from the court to serve the application on Kanu's counsel, Maxwell Okpara. Kanu's Anthony Okpara object. Kanu's counsel responded by saying the DSS lawyer's plea was an attempt to prolong subjecting his client to solitary confinement and order inhumane punishment. Meanwhile, Simon Enoch, the lawyer for the Attorney General of the Federation AGF, stated that he had submitted an application for an extension of time to regularize their counter affidavit. Neither the HIPOB Leaders Council, Okpara, nor the DSS lawyer objected to the application. Justice Taiwo, who observed that the case was coming before him, for the first time scheduled a hearing for February 28. Kanu, through his lawyer Okpara, was said to have sued the DSS Director General, the office, and the AGF. Joseph Wright gathered that Kanu's lawyer, Okpara, asked the respondents to respect the right of Nigerian citizens by adhering to the requirement of Chapter 4 of the 1999 Constitution as amended and the African Charter on Human and People's Rights, Ratification and Enforcement Act while carrying out their authorized duties. He also urged the court to rule that Kanu, even as a detainee, was entitled to the legal freedoms of thought, conscience, and religion. A declaration that the applicant, even though a detainee, is entitled to the enjoyment of his right to dignity of the human person as guaranteed under Sections 34(1)(a) of the 1999 Constitution as amended. A declaration that the respondent action in continuing to keep the applicant in their detention facility without transferring him to the Kuje Correctional Center is subjecting the applicant to mental torture, given that it is not the place designated for keeping awaiting trial inmate, etc. The lawyer then urged the court to issue an order instructing the respondent to immediately grant Kanu access to facilities and materials for religious practice, as well as an order directing them to remove Kanu from solitary confinement, among other things. The DSS disagrees and files a counter affidavit. However, PM News further revealed that the DSS disagreed with Kanu in a counter affidavit deposed to by Hamza Pandogari. Pandogari said that Kanu was apprehended by personnel of the first and second respondent on reasonable suspicion of treason and terrorism by inciting violence against the violence of Nigeria under the pretense of secession. According to the officer, Kanu is the leader of the outlawed organization known as the IPOB. He stated that he was currently on trial before Justice Binta Nyako on a 15-count accusation. Pandogari stated that, despite the fact that Nyako had previously admitted Kanu to bail sometime in April 2017, he jumped the bail but was later rearrested to complete his trial. In violation of Kanu's affidavit paragraphs 4A and B, the officer stated, there is no such order of court that applicants should have unrestricted access to the medical practitioner of his choice while in first and second respondent custody. It further stated that contrary to popular belief, Kanu was receiving enough and high-quality medical care as needed. The applicant enjoys direct and unrestricted access to medical practitioners who are experts in their various fields of medical practice, Pandogari said. He claimed that among the experts who had been attending to Kanu's health were Dr. Ho Fasan, consultant cardiologist from the National Hospital, Abuja, Dr. Hey Owumango, consultant gastroenterologist, University of Abuja Teaching Hospital, and Prof. Mbakwe, consultant cardiologist, Lagos State University Teaching Hospital. That apart from the regular routine medical checkup, applicants get promptly the required medical attention upon any request or complaint by applicant relating to his health, he quipped. According to the officer, the applicant Kanu has never missed a trial due to illness. He claimed that, contrary to popular belief, the DSS never tortured Kanu physically or mentally while he was in its custody. That while in custody, applicant enjoys several privileges including, but not limited to, entertaining a total number of 6 visitors of his choice every week, 3 each on Monday and Thursday, the days set out by the court as applicant visiting days, he did add. We've come to the end of our today's news.